Yeah. So again, thanks for having me. My name's Justin Sanders. I'm a local IP attorney. So technically, I'm a registered patent attorney. So not all IP attorneys can handle patents, but I'm able to do that as in addition to trademarks, copyrights, trade secrets, kind of the whole gamut of intellectual property. So I'm with a local firm called Entralta. We're what you would call a virtual law firm, meaning that rather than having a physical office, we just work out of respective home offices. We've been doing that since about 2014. So it's one way that we're able to keep costs down for our clients. And anytime the client wants to meet with us, we either meet at their office, we meet at a location like the startup incubator, for example, or coffee shop, just whatever is convenient for the client. But realistically, most of my clients are either too busy to meet in person or are located somewhere in another state, another country. And so with Zoom, email, phone, and everything, it all just ends up working out. Just being a virtual setup, like I said, the biggest benefit being saving our clients money just with the lower overhead. Um, we're all seasoned professionals here. We each have, I've got about 15 years of experience. Everyone else has at least 10 in our group. We all have different technical backgrounds. And so right now there's 3 attorneys. Between the 3 of us, we can handle really any kind of technology on the patent side. And then on the trademarks and copyrights, I handle all that for the firm. So uh, we focus primarily on what's called the transactional side of IP. So what we're doing is we're helping clients identify what they have, filing applications to protect what they have, and then we help them monetize it, help them enforce it to some degree. But that is the one aspect that we don't handle all the way through on enforcement. So we're not a litigation firm. So we'll send cease and desist letters, we'll negotiate settlements and all that. But if push comes to shove and a lawsuit has to be filed, that's where we would hand the client off to an actual litigation firm. It takes a lot of, of people power to handle full-fledged infringement litigation, and we're just too small to handle that. And so that's kind of where we draw the line really as far as the services that we offer. But realistically, most cases don't actually get to full-fledged litigation. And so usually we're able to come to reasonable settlement terms and kind of help the client all the way through even enforcement efforts like that. So yeah, I mean, I won't spend too much time talking about our firm, but that's kind of the long and short of it. Is we provide cost-effective, competitive legal services, and we do it based on flat fees. We don't bill hourly. I don't nickel and dime. I don't bill for phone calls and emails, things like that. I encourage my clients to call me, but yeah, happy to answer any other questions or help you with anything you might need on the IP side of things. So today we'll talk about, as you know, trademarks, and specifically what we'll cover is first we'll start off with just some trademark basics, just to give you kind of a foundation and a general understanding of what trademarks are, especially if you plan on trying to file your own federal trademark application. You want to know some of these basics. We'll also then talk about trademark searching to check to see if a mark is potentially available for use and registration. And then we'll also go over just briefly kind of federal trademark filing. I'll walk you through the application, show you what it looks like, talk about the things that go into the application. So again, if you wanted to try to tackle it on your own, you can definitely try that. I will say though, it is something where if you do enough research and preparation, it is something you could do on your own, but there are a lot of pitfalls along the way. And so typically it's better to have an attorney like myself help you with that process right at the outset to avoid those pitfalls, because sometimes, depending on what the deficiencies are in an application, sometimes the only way to cure those deficiencies is to start the process over and file a new application. And so again, I mean, if you're comfortable with tackling it on your own, more power to you, but definitely something to be cautious about and to do carefully. But hopefully with this presentation, you'll again have that foundation to try to take those steps on your own. So just generally then, a trademark, before we get into that, so there's different types of intellectual property. Again, there's the main four are patents, trademarks, copyrights, and trade secrets. And so obviously we're going to focus on trademarks today, but the thing to remember is the products and services themselves that you might take to market, those would be protected through one or more of a patent, copyright, or trade secret. So those three types of intellectual property kind of protect the products and services themselves, or aspects of those products and services. Trademarks, on the other hand, are the source identifiers that you place on those goods and services when you take them to market. So the legal definition is basically non-functional, unique source identifiers that are used in connection with providing goods and or services. So the common examples would be things like brand names or company names. It could be things like logos, like the Nike swoosh, for example. It could be taglines like "Just Do It," and then there's some less common types of trademarks, like, for example, jingles. So the NBC chimes, when you see their station identification, that chime is protected as a trademark. Product packaging and product configuration could also be protectable as a trademark. So, for example, the Coca-Cola bottle shape, that classic bottle shape, it's viewed as what's called trade dress, which we'll talk about briefly. But that's a form of trademark rights, meaning that when a consumer sees that shape, they automatically associate that shape with the company behind that shape, which is Coca-Cola in that case. It could even be things like product color. So there's a company called Owens Corning that sells insulation, and they sell pink colored insulation. And so they have what's called, again, trade dress rights on the color pink in connection with insulation, meaning that no other insulation company could sell pink colored insulation, because, again, consumers have come to associate that color of that product with Owens Corning behind that product. It could even be things like store appearance and decor. So, for example, uh, the Apple Store, kind of that minimalistic look. They have trade dress rights on the look and feel of their stores. And so again, it really is anything that could be used as a source identifier, or something where when a consumer sees it, they associate what they're seeing with you as the company behind it. Again, though, especially for startups, usually what you're going to be focusing on is your company name. If you have certain product names, you'd be focusing on those. Maybe if you have a logo or taglines, those are typically the primary focus. But and then sometimes trade dress is something we would look at as well if you have a product that has a unique look to it. So what a trademark really gets you is the exclusive right to prevent competitors from adopting confusingly similar marks in connection with the same or competing goods or services. So when you boil it down, trademarks have this kind of ancillary benefit of protecting the mark owners, but really what it is it's a consumer protection type of law, where the goal of trademark rights is to prevent consumer confusion. These laws they basically want to avoid the situation where you've got Nike shoes and then you've got Nike but spelled with two E's sitting side by side on a shelf, and then a consumer buys the Nike with two E product thinking it's the legitimate Nike product, and then they take it home and the shoes fall apart, and now they think that the real Nike is selling shoddy products, and it just creates all this confusion. And so the trademark laws are in place to prevent that. They want each good and each service to have a sufficiently distinctive mark so that consumers know who the company, or what company is behind the particular goods and services they're purchasing before they actually make those purchases. So when you're looking at this issue of trademark rights and whether you might be infringing someone else's rights, again, it's not just whether someone is using the same exact mark as you, but if it's confusingly similar, then there still could be an issue there. And so there's this multi-factor test that the courts use, as well as a trademark office. But the two main factors that they weigh are the likelihood, or sorry, the similarity of the marks themselves and the similarity of the underlying goods and services. And it's kind of the sliding scale test where if the more similar the marks themselves are, the less similar the underlying goods and services have to be for there still to be this likelihood of confusion, and vice versa. So again, going back to my Nike example, where you've got Nike and then Nike with two E's, if they're both being sold in connection with shoes, again, the marks themselves aren't identical, but they're still close enough where under the circumstances, because it's the same goods, there could still be this likelihood of confusion. But with that said, then on the other hand, if there's an identical mark out there to yours, but they're in a completely different space, such that then there's no likelihood of confusion, then there would be no issue. So the example I always give is that with the mark Delta, where you've got Delta Airlines, Delta Dental, Delta Faucet, and probably a lot of others, where it's the same exact mark, but the underlying goods and services are so different that no consumer is going to reasonably believe that one company is behind an airline, dental services, and faucets. Another example is with the mark Dove, where you have Dove soap and Dove chocolate. Again, it's the same exact mark, but the underlying goods are so different that consumers aren't going to confuse the fact that it's the same company. They immediately understand that it's probably different companies. And so all that's to say is that as you go, and we'll kind of talk about this later with when it comes to searching, but when you do start searching to see if anyone else is using the mark that you want to use, if you do, let's say, a Google search and you come up with some results, even if it's the same mark, that should never be the end of the inquiry, because you want to actually see what they're doing under the mark. And if it's something in a completely different area, completely different market, then you're probably going to be okay. But with that said, too, if you're finding similar results, that would probably be a good time to talk to an attorney, a trademark attorney, because again, those are the two main factors that courts weigh, but there's other factors as well. And just better to get an actual legal opinion at that point before you actually spend time and money pursuing something. Because I mean, the silver lining when it comes to trademark infringement is if you do happen to use a mark that's owned by somebody else, usually what happens is you'll get a cease and desist letter where it's kind of a shot across the bow, where they say, we want you to immediately stop using this mark. And as long as you do, then it's usually okay. Where, in other words, they typically aren't going to demand any kind of monetary compensation right at the outset. They're within their rights to do so, but in my experience, usually monetary damages are not something that's demanded right at the outset when it comes to trademark infringement. Now, if you push back and you don't comply with their demands right away, they might ask for money. But there's still the downside of having to then spend time and money rebranding, reconditioning your consumers. So either way, there's going to be time and money spent or lost in having to rebrand down the road. So better to kind of do this research right at the outset, to make sure that you're going to be free and clear to use a mark before you spend any time and money going down that path, and particularly before you spend time and money filing a patent or a trademark application. Before we go further too, I should say, if anyone has any questions at any point, just feel free to chime in and interrupt me with your questions. I know we're going to be covering a lot of different topics, and so better to just tackle questions as they come up. I'll try to keep my eye on the chat window as well, but feel free to just unmute yourself and chime in when you have a question. So one more thing to keep in mind here on this slide is these trademark rights are country specific, meaning that if you want to have enforceable rights in the US, you have to have, and US is kind of a unique animal, but you would have to register your rights, let's say, in the US. If you want to have rights in Europe, you've got to file a trademark application in Europe, etc. So yeah, just keep that in mind. And then depending on where you actually want to do business, those would be the countries where you'd focus on. And again, we'll touch on that a little more in a bit. So as far as the types of trademarks, again, I mentioned, like, you've got brand names, product names, company names, logos, etc. But they all kind of fall within these three primary categories, if you will. And I say primary because there's other things like jingles and things that kind of be their own animals. But typically what you're looking at when you're dealing with trademarks is you've got what are called word marks. And then you've got stylized marks, and then kind of the outlier is trade dress. So when you say word mark, basically what we mean is just the plain text characters, that it's not limited to any particular font, color, stylization, etc. Meaning that if you were to get a registration on the words Coca-Cola, for example, you could use it like this, or you could put it in a different font. You could add design elements to it, etc. That word mark is going to cover any stylized version of that phrase that you're registering. And so because of that, word marks tend to be the broadest type of trademark registration or trademark rights that you can obtain. And so typically then, assuming that it looks like you're free and clear to use that name, when you file your first application, at least, what you're going to want to file on is the word mark, because again, that's going to be the broadest. And another type of mark is what we call a stylized mark, where rather than the plain text characters, it's literally like a stylized version of the mark. So this Coca-Cola logo right here would be considered a stylized mark, where it's the words in a particular font. Now, it's not going to be as broad a protection as the word mark. I mean, if you had only a registration, let's say on this stylized mark for the words Coca-Cola, if someone else used Coca-Cola in a different font, you could still potentially get them on a trademark infringement claim just based on a stylized mark registration, but it's just not as much of a slam dunk case as if you had the word mark registered. So typically what I advise is stylized marks be reserved for, especially for startups when you're on a tight budget. Go for the word mark first and foremost. And then if you have particularly a mark that has design elements to it, or maybe you have a logo that's only a design. So again, for example, like the Nike swoosh, or sometimes when I'm working with clients that have like an app, they have like their app name, and then they might have like an icon that they use like for the app itself when a user clicks on the app. And so they might register that icon like as a separate stylized mark, and then just register their name as a word mark. But registering, like if for Coca-Cola, for example, if you were a startup, registering a stylized mark like this, it's probably not going to get you a whole lot of protection there. Again, if it's in the budget, it's certainly an extra step you can take, but I always tell clients, focus on the word mark first and foremost. Any other like logos would be kind of secondary, and then any kind of fonts that you might have or stylized versions of your name would be like a tertiary consideration. And again, that's something a trademark attorney can kind of help you strategize over. It's all case by case. I mean, the benefit, or one of the main benefits of registering a stylized mark is, let's say you have this as your logo and you register this. If Pepsi were to use their name Pepsi and write it in the same script font, for example, they wouldn't be using the words Coca-Cola, so they wouldn't be infringing Coke's word mark. But if they were using the same script font to write Pepsi, then they would still be infringing that stylized mark, because it's still confusingly similar, where a consumer could just see that script font and mistake it for Coca-Cola, just being familiar with that script font, even though it actually says Pepsi, and there's still that consumer confusion that's going on. And so those would be the situations where it could be beneficial to register a stylized mark where it's just your name in a particular font, if you think there's a chance that some of your competitors might try to copy that font. But again, I mean, even there, that's something where you could typically table that until it's in the budget if you're a startup. So word marks are where you want to focus on. And that's something I'll show you where you do specify in the trademark application, whether you're doing a word mark or a stylized mark. So again, trade dress, as I mentioned, that's like product configuration. So this Coca-Cola bottle shape, or if you have any other product that has a unique look or color scheme or shape, etc., that could be something that's beneficial for you, particularly if it's something that may not be rise to the level of being patentable. I mean, trade dress rights, if you've heard of design patents, trade dress kind of functions in a similar fashion as a design patent would. And oftentimes when I have clients that want trade dress protection, typically they're also filing a design patent application as well, because there's additional benefits there. It's all case by case though, and one thing to consider is if your product has already been out there for some time, you might not be able or be eligible to obtain a design patent anymore, but you could still potentially get a trade dress registration. Plus, design patents are limited to only 15 years of protection, whereas trade dress rights, just like any other form of trademark, can go on in perpetuity as long as that trademark is actually used. So again, with the Coca-Cola bottle shape, they can have rights to this in perpetuity as long as they continue using this shape in some form or fashion in their marketing materials or the actual products they sell, et cetera. So again, it's all case by case as far as like what's the best strategy for any company, but that's always something to consider if you have a product that has some unique aspect to it. So I mean, some examples that I've done recently is I helped a client get trade dress rights on a candle that had like a shimmery gold appearance to it, where no other candles on the market had that same type of appearance, and that kind of set her company apart. I helped a client get protection on a Hawaiian shirt that had reflective patterns on it, because a lot of construction workers, they call it Hawaiian Fridays, where they get to wear Hawaiian shirts, but usually they wear their reflective vests over top of the Hawaiian shirt. My client just put the reflective tape on the Hawaiian shirts themselves, and so he's got protection on that, where he's now the only company that can actually sell Hawaiian shirts that have reflective patterns on it. And so if you have some kind of edge like that with your products, where maybe it's not so much a functional improvement or difference over your competitors, but more aesthetic, then trade dress rights could be something worth exploring. But again, by and large, most companies are just going to be focusing on word marks and sometimes stylized marks. So this kind of goes without saying, but a mark has to be distinctive enough to function as a unique source identifier. So I mean, part of that means that it has to be sufficiently unique compared to what your competitors are doing, like as far as their trademarks. But it also just has to be a strong enough mark in and of itself. And so when you're considering like how strong of a mark you have, and strength of a mark basically goes to how easy it would be to then enforce those rights if someone's tried to use a similar name, meaning that the stronger your mark is, the less similar a competitor's mark has to be for you still to be able to stop them from using that mark. And so trademarks are basically judged on this spectrum that you see here, where the weakest end down here is what we would call generic, and the strongest type of mark is what we would call fanciful. And so taking, if as an example, if you're selling shoes as your product, if you tried to use just the name shoes as your trademark, that would be what we considered a generic term. So generic terms are essentially just the plain English terms that are used to describe that product. So if you're selling shoes, shoes would be generic in that case. Though, as I note here, I mean, strength of a mark is always relative to the underlying goods and services. So it's not just in this vacuum or just universally applied, but rather you're always looking at what the underlying goods or services are, and then comparing that to the mark to see where on the spectrum your mark would fall. So if I was selling shoes, shoes would be generic, but if I was selling cosmetics, the term shoes would be arbitrary. And so this red line basically indicates that below this red line, this is not something that's protectable as a trademark. Anything above the red line is potentially protectable as a trademark. So if your name is just some generic term, then it's not going to be something that you're going to be able to protect. And it makes sense, because if you're selling shoes, you don't want a competitor to try to now send you a cease and desist letter and say, no, you can't use the term shoes to sell shoes. Well, it's like, well, how do you describe your goods then to your customers? And so that's why generic marks aren't protectable. So one step above generic is what we call descriptive marks, and that's basically where the mark itself describes some aspect or characteristic of the underlying goods or services. So again, if I was selling shoes and I wanted to have the brand name as soles, I mean, a shoe has a sole, and so it's not immediately apparent to a customer, to a consumer, that that is an actual brand name. Like if a consumer sees the word soles, they're probably just going to assume that that's what you're selling. They don't necessarily immediately think that's your brand name. And so because of that, descriptive marks, they are potentially protectable as trademarks, but you have to do a little more work where you've got to condition consumers over time that, hey, this is actually a brand name. This is not just the name, what I'm selling. This is my brand. And so through enough marketing efforts, through enough sales, a descriptive mark can, what we call, acquire distinctiveness over time. And because of that, these are protectable as trademarks. It's just you got to do that extra work. Now above the green line, these are all types of marks that we consider inherently distinctive, meaning that the marks are unique enough, they're not descriptive or anything, so they have enough uniqueness, enough distinctiveness there to where when consumers see these, they immediately recognize that as a brand name rather than as some aspect of the product that you're selling. And so the first type of mark is what we call suggestive. And so it's kind of similar to descriptive, but it's not as descriptive. So meaning that the consumer has to make some kind of mental connection between the mark itself and the underlying good. So again, if you're selling shoes and your mark is marathon, I mean, you would wear shoes when you're running a marathon, and that's the mental connection in that example, where it's not immediately apparent on its face, but it's still kind of close. But suggestive marks are, again, inherently distinctive enough to be protectable as a trademark. One step above that is what we call arbitrary marks. And so that's where you take an actual term that has no relevance to the underlying goods and services. And so an example is, again, for shoes, there's a company called Reef that sells sandals and shoes. There's a Reef has nothing to do with shoes. So there's this arbitrary connection between the mark and the underlying goods. Or like another one would be Apple for computers. And so one step above that is what we call fanciful marks. That's just basically where you make up some term that didn't exist previously. So KEDS, for example, is just some made up term that they came up with as their brand name. And so fanciful marks are the strongest form of trademark rights as far as, again, on that spectrum when it comes to enforceability. Now, I mean, there's no right or wrong end of the spectrum to be on when you're coming up with your brand name. There's pluses and minuses at both ends of the spectrum. I mean, that you definitely don't want to fall in the generic realm because there's nothing protectable there. But I mean, the benefit of having a descriptive mark is at least to some degree, what you're selling is going to be almost immediately conveyed to the consumer once they see your brand name. So you don't have to spend as much time or even marketing dollars on conditioning your consumer as to what it is you're selling. It's just kind of more apparent on its face. But the downside with descriptive marks is because they are closer or they describe some aspect of your goods and services, the likelihood that a competitor might try to adopt a similar name becomes much higher. So you're not spending as much money on the marketing side of things, but you're potentially going to spend money on the enforcement side of things, because the only way to maintain trademark rights is to maintain exclusivity. So if a competitor comes out with the same or similar name, you need to stop them. You have to spend the money to stop them from doing that in order to maintain that exclusivity. Because if you don't, the more prevalent a mark becomes in an industry, the weaker your rights become as far as your trademark rights, until eventually you just lose all your rights if the mark just eventually becomes so widely used, it's just generic. And I mean, that's just something that's always on the minds of mark owners. And you see this in examples like with Xerox, where Xerox is a brand name. They sell facsimile machines or copiers, but people generically use that term to say, "Hey, go Xerox this for me," and so they are constantly putting out ads in different magazines and publications. Just the whole purpose of the ad is just to remind consumers that, hey, Xerox is our brand name, but we actually sell copiers and facsimile machines. Same thing with like Q-tips for cotton swabs or thermos for insulated containers, where all these terms are at risk of becoming generic. They're almost a victim of their own success. But you have to maintain that exclusivity, otherwise you eventually lose your trademark rights. So with descriptive, again, that's the downside, is you potentially have to spend more money on the enforcement efforts, not necessarily, but just the risk becomes higher. Where at this end of the spectrum, if you have a fanciful mark, just some made up term, the likelihood that someone else is going to adopt that same exact term or something similar in connection with competing goods and services is much lower. And so you typically aren't spending as much money on the enforcement side, but you're at the same time, you're likely going to have to spend some money telling your consumers, teaching your consumers what it is you're selling. Again, like Kinko's for copies, like if someone were to just, back when they first started, if you heard the name Kinko's, you'd have no idea what it is they did. Or even Apple for computers. Like if you're to say Apple to somebody, they would think fruit, not computers. I mean, obviously now over time, they've conditioned their consumers to now everybody knows what Apple provides. And they probably think more computers than fruit now for most people. But all that's to say is that, again, there's no right or wrong end of the spectrum to be on. It's just what do you want to focus your money on, basically. And it also comes down to like what name you come up with, and how in love with it you are, and then you just decide like, okay, where does it fall in the spectrum, and is it worth spending the money on those efforts for this mark? Do I like it enough to take the next steps? But just something to keep in mind as you're coming up with the name that you want to use. So as I mentioned, with the U.S., we kind of have a different system as compared to most other countries. The typical protocol for most countries is, if you want to have enforceable trademark rights, you actually have to file out an application in that country and obtain a registration. And once you have that registration, you now have enforceable rights against third parties. In the US, we have a different system where you've got what are called common law trademark rights, which I'll get into in a second. But then you also have state trademark rights as well as the federal trademark rights. So we've got this three-tiered system in the US. They're all valid forms of trademark rights, and they all have to be taken into consideration. But they all kind of have different scopes of enforceability and protection. So with common law rights, anytime you see a TM or an SM next to a brand name, that's an assertion of common law trademark rights. So TM stands for trademark, SM stands for service mark. So sometimes when a company is only providing services, they'll use an SM. Legally though, even if you're only a service company, you can still use a TM. And most people do that anyways, just because TM is more widely recognizable as kind of the trademark symbol. So yeah, you can use a TM or an SM. It technically neither is required, but it's definitely encouraged, just because by putting that on your marks, you're kind of putting the world on notice that you have some form of trademark right. So it's to, at the very least, discourage competitors from trying to use the same or a similar name. And so these common law rights arise automatically just by virtue of your use of the mark. So in other words, on day one, when you launch a company, when you start providing goods and services, you are legally allowed to use a TM or an SM next to your brand names, your taglines, your logos, etc. There's no application process or anything. You don't have to file an application. You don't have to pay any fees to anybody. It's just an automatic right that arises by virtue of your use of the mark. Now, with that said, though, the rights are limited based on where you actually have been doing business. Particularly, they're geographically limited. So, for example, if you're selling T-shirts in Southern California, your potential common law trademark rights would be in Southern California. So, if someone in Northern California or a different state starts even using the same exact name as you, if you don't have any sales there, if you don't have any presence in that geographic region, you would not be able to stop them based on your common law rights. Furthermore, even in Southern California, if you've only sold 1 or 2 t-shirts, you're going to have relatively weak common law trademark rights as compared to if you've sold 10,000 t-shirts in Southern California. And so that is one of the downsides of just relying only on common law rights is, yes, it's a free form of trademark rights, and it's certainly something you can rely upon like when you first launch. But if you actually were to go in and try to enforce those rights against an alleged infringer, it's very difficult to enforce. For one, you're dealing with state law instead of federal. So if you're selling goods in multiple states, and let's say you're based in California and someone in New Mexico or somewhere, or New York wants to or has been using the same name as you, even if you have common law rights in that state, you're having to hire an attorney to go sue in that state based on that state's trademark laws, and it's inconvenient for that reason. Plus, when you actually then go into court, it's not just presumed that you have these enforceable rights, but you're having to show the court that you've actually made sales, like where you've made sales, how many sales you've made, how much money you and how you've been marketing, basically having to prove that you've done enough business in that geographic region to actually establish enforceable trademark rights. And so it's very clunky to try to enforce these. But it is something, again, where right out of the gate, you at least can assert some amount of common law rights, at least to discourage competitors. But pretty soon after launching, you want to look at either a state or a federal trademark registration, which I'll get into in a second. So the term of these is basically it'll last for as long as a trademark is used. And if you stop using the mark for a period of like 3 years, usually, then it's presumed abandoned. So the rule with trademarks is kind of use it or lose it, basically. So with state trademark rights, there is an application process. It's not a commonly used form of protection these days, just with the internet and e-commerce and everything, where, I mean, most companies are going to be doing business in more than one state. But if hypothetically you plan on only doing business in a single state, like if you're based in California, you only plan on having California residents as your customers, then you might consider doing a state trademark registration. And then with that, even if you only are doing business in Southern California, let's say, if you got a state registration, you now have statewide rights. And so you don't actually have to have actual sales in other geographic regions within the state. It's just by virtue of that registration, you now have statewide protection. But again, it's just not commonly used these days, because even, let's say if you're a restaurant based in California, if you have people coming from other states to eat at your restaurant, that's considered using your mark in interstate commerce, which makes you eligible to get a federal registration instead of a state registration. So there's just very limited situations these days where a state registration makes sense, but it still is an option. And every state has this process where you'd file an application with the Secretary of State in that particular state. It's, again, would give you statewide protection. So federal rights, that's the one typically that the companies go for sooner rather than later, at least for their most important marks. And that's anytime you see the R in a circle, that's an assertion of federal trademark rights. So it's a registered trademark. And when they say that, that's what they mean, is it's registered federally with the United States Patent and Trademark Office. And so just like with state applications or state registrations, these federal registrations also have a formal application process and fees that you would pay. And once you have those rights, it automatically gives you protection throughout the U.S. and all U.S. territories. And the only requirement in order to actually obtain the registration is you have to be using the mark in interstate commerce. So, I mean, technically speaking, if you're based in California and you're selling t-shirts, the second you sell a shirt to someone in another state branded with your trademark, you're now using the mark in interstate commerce, and you're eligible to obtain that federal registration. And so even if you've only made sales in one other state, now suddenly you have protection in all 50 states and all U.S. territories. So the other benefit is you don't have to go through all these hoops to prove like where you've made sales, how many sales, etc. You effectively just essentially walk into court waving your registration certificate around. Obviously not literally, but they then presume those as valid rights. And it's on the defendant to prove that you don't have valid rights for one reason or another, but you don't have to prove up all these extra things like you do with common law trademarks. Um, and there's even the benefit of if you haven't yet made that first sale to an out-of-state customer, you can apply earlier based on what's called intended use, and I'll mention this in a little bit as well. So that you can kind of lock your name in at a preliminary stage, and then complete the process down the road once you actually start making those sales across state lines. So once you come up with your name, you can file that application right away, get it in queue, get it examined, and then kind of complete the process in a year or two or three down the road as needed. Again, I'll talk about that in a little bit. And again, similar to common law rights, both state and federal trademark rights can last in perpetuity as long as you continue to use the mark and as long as you continue to pay the renewal fees. And so for at least for California, I think they went from 10 years to 5 years. So like every 5 years, you have to pay a renewal fee. For federal trademarks, the first renewal is due 6 years after registration, and then it's basically every 10 years measured from your registration date. So it's not a very frequent renewal fee that you have to pay, but it is something that's required if you want to maintain those rights. But again, because these go on in perpetuity, this is an asset of your business to where if you sell your business at some point down the road, your trademarks would be among those assets that you could sell to somebody else. And they basically then step into your shoes and they can continue paying these renewal fees and continuing these trademarks in perpetuity. So there's a lot of value in these brands, and especially if it's for a product or service where you don't have any patentable aspects, where it's more or less a commodity product that other competitors are selling as well. In those situations, your trademark is what sets you apart. It helps customers find you, and all that goodwill that's built up in those marks has a lot of value. And so taking these steps can help you maintain that value within your business. So this is just a little diagram to just kind of illustrate the steps that you take to file foreign applications. And again, it's all country by country, as I mentioned before, but typically the strategy that you take is you file in the US first, and you have this period of 6 months where any foreign applications you file within this 6-month period, they're backdated and given the same filing date as your US application. So in other words, I could file my US application today, and 6 months down the road, I can file in China, and that Chinese application would be given the same filing date as my US application. And where that becomes beneficial is in other countries where they're all they focus on is these applications being filed rather than use of the mark. Your filing date is essentially your constructive date of first use. And so what happens sometimes is for more popular brands, if you file your US application and then let's say you launch your product, unscrupulous companies in other countries could file applications before you have a chance to, and then essentially hold that brand hostage and prevent you from using that mark in that country unless you pay them some exorbitant fee. So the benefit here is, even let's say you file your US application, if 3 months down the road someone files an application on the same mark in China, as long as you file your application within the 6-month window, your application will end up predating their filing, because your application will get this earliest filing date. And so it's what we call a priority claim. So this 6-month window is what we call a priority window in order to claim priority to an earlier application. And so it's definitely something to consider, particularly if there are other countries where you plan on and having some presence within the next 1 to 3 years. And that's the thing to keep in mind, is you want to make sure that you're within 1 to 3 years from filing in other countries, because if you're beyond 3 years, it could be premature to file now in those countries, because similar to the US, in other countries, if you fail to use a trademark within like roughly a 3-year period, then that registration is ripe for cancellation based on non-use or abandonment. So this is a nice thing to take advantage of for countries where you're within that kind of 1 to 3 year window, but it's not required. So like with patents, you've got like these very rigid timelines where you're dealing with public disclosure issues and stuff. And with patents, if you don't file within a certain period of time, you're prevented from filing at any point thereafter. With trademarks, there's no such rule. I mean, the goal is simply just to make sure you're filing your application before anyone else does. So I mean, that's the unknown, but it certainly could be the case where you file your US application and then a year or two down the road, you might file in other countries. So it just depends on when you're within that roughly 1 to 3 year window of time. And again, I mean, any country where you plan on using your brand, you want to make sure that you're getting registrations in those countries, because there's the enforcement aspect where you want to have these rights to be able to stop others from using the same or similar marks. But there's also the freedom to operate aspect where, again, if you don't file in these countries, if someone else does, they could prevent you from using your mark in that country. And this happens all the time where you see these even large companies where they have certain brand names for their products in the US, and then other countries they have different names for those same products. I mean, sometimes there's translation issues where it's like an offensive term in other countries, but oftentimes what the reality is that someone else has already registered that mark in connection with similar goods or services in those countries, and they have no option but to go with a different name in those countries. And so the sooner you take those steps, the better, as long as you're within that 1 to 3 year window. And I mean, realistically, this is not something that you would do on your own. This is at the point where you would bring in an attorney. Even if you filed your US application on your own, you would want to have an attorney's assistance to take these foreign filing steps, if for no other reason than just to have one individual be the point of contact for all these various foreign associates around the world wherever you're filing. It's nice to have an attorney be kind of the centralized point of contact to kind of handle all these applications for you. So with trademark searching then, so when the first step, and when I say trademark searching, it's searching is to see whether you're free and clear to use and register a mark, making sure that your mark is sufficiently unique. And so one of the first steps, I mean, obviously step one is coming up with the name that you're considering, or maybe a short list of names that you're considering. After that, you want to figure out what goods or services that are you plan to sell or that you are selling, and then coming up with appropriate descriptions. So as you'll see, one of the main components of a trademark application in the US and elsewhere is the what we call an identification or of a description of goods and services. So you've got basically the mark, and then you have to specify what it is you plan to sell under that mark. Those are the two main components that you're submitting to the trademark office, so that they can determine whether your mark is sufficiently unique based on the goods or services you plan to sell. And so the USPTO has this helpful database called, and I think they recently changed the name. I think they just call it the ID manual now, but it's basically a database of what would be considered acceptable descriptions. So they have this whole database of kind of pre-approved descriptions where if you use those descriptions, they will accept them as adequate. The alternative is to come up with your own descriptions, your own custom descriptions, in which case there's a chance that the trademark office could object to those as being like too vague or too indefinite or just requiring clarification. So if you're able to use the pre-approved descriptions, it kind of avoids that whole issue. And it also means you can get, you don't have to pay as much in filing fees when you file your application. So there's a lot of benefits to using these pre-approved descriptions. And so after you come up with your name or a list of potential names, the next step is to preferably search this database, and I'll show you how to do that in a second, to figure out the best description for your goods and services. And as part of that manual, you'll see that each description lists what's called a class number next to that description. And so basically, all goods and services fall within to about 45 different classes. So for example, clothing falls within class 25, downloadable software and other kind of computer hardware is class 9, like web-based software is class 42, beverages class 30, but then you've got non-alcoholic and alcoholic. So basically all these different goods fall within these different classes. And the way it works is when you file your application, again, you're providing the mark and you're providing the descriptions of goods. And depending on how many classes are implicated, that's how much you pay in filing fees. So it's basically like $250 or $350 per class is what you pay for a US application right now in filing fees. And so, I mean, obviously then you think, well, the fewer classes, the better, but sometimes you can't help but implicate multiple classes depending on what it is you're actually selling or plan to sell. So again, taking this step helps you figure out the best descriptions possible to use, and it also helps you figure out how many classes are going to be involved when you file that application. So once you have those details figured out, then the next step would be to actually search the USPTO database. And so the Trademark Office has an online database of all registered and pending trademarks. And so you're able to do a search. And again, that's something I'll show you in a second here. To then figure out, okay, what's already registered in this class or what's already pending in this class. And you'll see that and I'll show you in a second. There's a few different or a couple different options as far as the way that you can search. And the most useful is what's called the free form search, where you can, it's basically like a Boolean search where you're not just searching a term, but you can use like wildcard characters and things like that to do a more kind of surgical search in specific classes and everything else. And so always best to use alternate spellings, root terms, and wildcard characters. And again, I'll illustrate what I mean by all that when you do these searches, so as to broaden the search. Otherwise, if you just do like a basic search for the specific mark that you're considering, it's not going to show you alternate versions of that term. Again, particularly if there's different spellings or different kind of derivative terms based on this one root term. So by broadening that search, again, you're getting a better idea of what's already in this field as far as potentially confusingly similar marks. And then another thing to always do as well, I mean, the federal database is the primary database. I mean, it is the one that the trademark examiners will rely upon. Trademark examiners are not going to look for common law trademarks. But if there is a common law mark owner out there, they could proactively themselves object to your registration. And so searching the internet for common law sources is always a good step to take as well, just so you have, again, a better understanding of what the field looks like in your particular market. So again, similar to the USPTO searches, try to use alternate spellings and root terms and wildcard characters to broaden those searches out to see what might turn up. So with that, let me bring up a different screen. Okay, can you all see? Can someone, just at least one person chime in? You can see it?
Yeah, we can see it.
Okay, so this again, this is that first step, the trademark ID manual, and so it's just you would put in kind of just plain English descriptions of some aspect of your goods or services. I mean, however you might describe them, and then it would show you a list of pre-approved descriptions that use that term. So for an example, let's say that I was wanting to sell scooters, and let's say I wanted my brand name to be Wolf. So again, step one, after I've come up with my proposed name, Wolf, for this type of product, I would search something like scooters, let's say. And so you'll see with this particular type of good, you'll see that scooters by itself has basically been deleted. It's not an approved description anymore. And The reason being is there's lots of different types of scooters in this case, and sometimes, and this is all case by case, sometimes you can be a little more broad or vague in your descriptions. Other times you have to be more specific. So for example, if you're providing business consultation services, is an acceptable description. You don't have to specify the types of services you're providing. But on the other hand, if you're selling clothing, you can't just say clothing. You have to specify the types of clothing, whether it's t-shirts, socks, pants, etc. And this is something you would discover as you search this database. Like if I were to search clothing, you would see that you can't just say clothing. You got to specify. And so scooters is kind of similar, where you see we could say push scooters, like if it's like just a manual scooter. If it's a motorized scooter, we could say something like motor scooters. You'll even see, like if you're selling toy scooters as opposed to just like a traditional, like a razor scooter or something. If it's more of like a toy scooter, that could fall within even a different class. There's class 28, where you see most of these other types of scooters are class 12. And so I would just scroll through here, and all these are pre-approved descriptions. So I would just look to see, okay, what's the most accurate description for my product? And it could be the case where, especially if you're developing some new product or technology, there might not be a pre-approved description for it. And if that's the case, you can still at least use these for kind of like a general template to kind of mimic, if you will, and just modify as needed. And again, the difference there is that it's just going to be a little more in filing fees that you'd have to pay. But the key is that you always want to be accurate. You want to be as broad as possible, but you still want to be accurate in your description of goods or services, because that could be very problematic if you're not, from both an enforceability standpoint as well as just to actually complete the registration. That's one of those issues where if you're not accurate, sometimes the only way to cure that defect is to refile. Not always, but sometimes. And so you want to make sure to be as accurate as possible, but still being as broad as possible based on, again, what you see in these other descriptions. So let's say, for example, that I was just wanting to sell like motorized scooters, kind of like the Lime scooters that you see for rent, things like that. So I would probably pick something like motor scooters. Yeah, I would probably say, just based on this list, or here's electrically powered motor scooters. And sometimes there will be multiple options for you, that all of them could be applicable. And so my advice, I mean, one option is you could include all of them. It's not wrong to do that. I always try to be as minimalistic as possible and as broad as possible. So like between these two, electrically powered motor scooter or just motor scooter. I mean, motor scooter could cover both electric and gas. So I would probably go with just motor scooters in this case. So being as broad as possible while still being accurate is always the goal here. So let's just say that motor scooters is what we want to go with in this case. And you'll see, again, there's this column here that shows you the class that these fall within. So motor scooters, like all other vehicles, and vehicle accessories, fall within class 12. So you would just jot that down on a piece of paper or wherever, and then from there, you could then jump into the trademark search database. And again, these URLs are in the slide deck, and Philip will distribute the slide deck after the presentation. So don't worry about trying to write these things down. I just need to refresh this because it's expires. So you'll see, again, this is like a basic search. So if you just wanted to search the term, like, again, like if my mark was wolf, I could type in wolf and search it. This is a database wide search though, when you do this basic search. So you see 3,652 results, and it's going to be all across the board, not just scooters. And so usually doing that type of search isn't the best. So what I always recommend doing is there's this freeform search. And when you do this one, there's all these different codes that you can search by, and if you click on them, they'll tell you a little more information on like what that code is for and everything. But typically, what I'll search is BI stands for basic index. So this is like what you would where you would type in the search the mark itself or whatever terms you want to search on based on the mark. IC stands for international class. So again, scooters falls within class 12 primarily. And so we would search 12, or you could do something like, again, with like 28 was another class. So you could do something like or class 28. And then it also that database includes both live and inactive marks. And if a mark is inactive, it's really of no concern because there's no enforceable rights there. I mean, there certainly is a chance that a mark could be revived. Let's say it accidentally went abandoned yesterday and it's going to be revived a week from now. That could be potentially problematic. So it might be worth searching every mark, but usually, at least as a starting point, I typically only search for live marks. So LD stands for live or dead. You'll see down here. And so this is just the syntax where you put whatever field code you're searching by for each of these things in brackets. Parentheses are used for the actual search terms themselves. And so, as I mentioned before, you always want to try to use like root terms, use wildcard characters whenever possible to broaden things out. Because if I were to only search for wolf, then typically that's only going to turn up instances of marks where wolf is a kind of a standalone mark. So if someone, let's say, had the mark red wolf registered and they made it all one word, if I just search wolf by itself, that might not turn up something like red wolf where there's a term immediately before. And so by putting this wildcard character first, that's going to cover instances where there is a term immediately before the term wolf. Same thing for immediately after. If they wanted, if their mark was like wolfine or something like that, having this asterisk here is going to turn up those marks as well. And then just thinking about it, the plural of wolf is wolves. So WOLV might be something also worth searching. I could have just done like WLL asterisk, but that could turn up a lot of other different terms as well. So it just, again, this is all case by case, and you just kind of have to get creative depending on what it is that you're looking to search on. But this is typically something that you would do for the mark itself, and then you specify which class or classes to kind of narrow that search so you're not getting 3,600 results, but something a little more manageable to look through. And then typically only focusing on live marks. So when I submit this query, you see, okay, so it's still giving me quite a few marks. So this is all of class 12 and 28, which is, again, all motor vehicles and accessories in 12. 28 is all kinds of toys and in addition to toy scooters. So if I'm getting this many results, what I might do then is go back and specify the types of goods as well. And so you see GS is goods and services. So what I could do is say something like, and let's say scooters or scooter GS. So now it's only going to turn up marks that have some form of this term wolf in class 12 or 28 that's live and it's in connection with scooters or singular scooter. See, so now it's down to only 7 marks. And you see, so there's multiple marks that use the term wolf in connection with these types of scooters. You could even click on each one and it'll show you like specifically what it is they're selling or purport to sell. So like this one, Max Wolf, does list push scooters, motor scooters, electrically powered motor scooters. And we could look back at He Wolf. So this is toy scooters. You could look at like, let's see, like Urban Wolf. And so you kind of click through each one to see like, so there's multiple marks that use the term wolf in connection with either push scooters, like vehicle scooters or toy scooters. And so in a situation like this, typically then this legal landscape is telling me that if I were to file an application just on the term wolf by itself, it's probably going to be rejected as being confusingly similar to some of these other marks that also incorporate the term wolf. And it makes sense, because if I were to suddenly get a registration on just the term wolf, that means that I can then go around and sue all these other people for infringing my trademark rights, even though they were using the term wolf much earlier than I was. And so but on the other hand, because of this crowded field, I might not be able to register the term wolf by itself. But because there's multiple wolf marks in this space, typically what this means is that if I were to add one or more non-descriptive, non-generic terms to my mark, then that could be a path forward. So for example, like if I were to try to register the mark red wolf, that's probably enough of a distinction in this case, because there's max wolf, he wolf, urban wolf. Like red wolf wouldn't be any more confusingly similar than any of these others are. So because there's already this crowded field of marks, the typical argument is that consumers have already been conditioned to recognize the fact that there's multiple wolf marks, and so they're going to do a little more due diligence if they find a particular wolf mark in connection with scooters to figure out what specific company is behind this specific brand. And so because of that slight distinction of adding just one extra unique term like red or something like that would potentially be enough then to allow you to move forward with that mark. So rather than wolf, I might go with red wolf or something else, and I would be able to use and register that mark based on what I'm seeing here. Again, you would still want to then, after you do this type of search, go to Google, and if I come up with red wolf, I would want to do something like red wolf scooter and see like what turns up. So I'm seeing like wolf brand scooters. I'm not seeing any red wolf though. So it looks like red wolf scooter would potentially be available for me to use and register in connection with my motor scooters. And so that's kind of the process you would go through for your mark. Again, you start by searching the goods to figure out the classes and the best descriptions. Then you do that search of the trademark office database, and then also do a search of Google to just make sure there's no common law sources that could pose a problem for you. And so then once you decide on a mark and you clear it, you see that it's free and clear for use, the next step would then be going through that application process. And so here, going back to the slides then, as I mentioned before, one aspect of the federal trademark application is actual use versus intended use. And ultimately, in order to get a registration, you have to actually use the mark in interstate commerce. So if I'm selling scooters, I have to make at least one sale to a legitimate out-of-state customer before my mark is being considered used in interstate commerce. And I say legitimate customer because it can't be a friend or family member. It can't be some related entity. It has to be like a legitimate customer that you sell or ship the products to. And again, it technically is selling or shipping. Money doesn't actually have to change hands. There's lots of companies out there that provide free goods and services. And the key is that those goods branded with the trademark or services branded with the trademark have to cross state lines. Whether they're paid for or not is a non-issue really. And so one of the things that you'll have to specify in your trademark application is whether you're filing based on actual use or intended use. And so actual use means that all the goods listed, all the goods or services listed have been provided across state lines as of the application filing date. So we've been talking about a singular situation where I'm only selling scooters, but if I was selling scooters and skateboards, let's say, if I've only sold scooters but haven't yet sold skateboards, I can't file based on actual use in connection with those goods. I would have to file based on intended use, and that's probably not the best example because those are two different classes. So let's say I was selling scooters and cars, let's say. And so if I've only sold scooters and not cars, then I'd have to file based on intended use rather than actual use. So this is a per class issue. So it's certainly possible where you could be filing based on actual use for one class and intended use for another. So again, scooters and skateboards. So skateboards are class 28, scooters are class 12. If I'm selling scooters but not yet skateboards, I could file based on actual use in class 12 and intended use in class 28. And these are just little boxes that you check in the application itself as you go through. As you go through the application. And so what you'll see, there'll be little text boxes you have to fill in, and these are the things that they ask you for when you file based on actual use. So they'll ask for the date of first use in commerce and the date of first use anywhere. So the date of first use anywhere typically is like if let's say you're based in California, if your first sale is to someone in California, that would be your first sale anywhere. And then your first sale outside of California would be your first use in commerce. And so they ask for both of those dates. Now, typically for the first use anywhere, if your first sale is to someone in another state, then your first use in commerce and your first use anywhere are going to be the same date. So it just depends on, again, your situation. In addition to those dates, the trademark office will ask for what's called a specimen of use. And it's basically they just want to see some kind of evidence to show that the mark is actually being used in connection with those particular goods or services. So when you're talking about products themselves, typically the trademark office is going to want to see the trademark that you're applying for either on the actual product or on the product's packaging. Sometimes if there's like a user manual, you could get away with, if the mark is only in the user manual, you can provide like a scanned copy or a photo of the user manual. But typically it's going to be either on the product itself or a tag attached to the product or the product's packaging. And you basically just take some photos. Technically, all you need is one if you can get a good shot that shows both the product as well as the mark affixed to the product or the packaging or the tag. And that's the purpose, is they just want to make sure that what you're applying for is actually being used in connection with the goods that you've listed. If it's services, typically what they'll allow is pieces of marketing material. So if you have a website or brochures or something that has the mark on the website or the marketing material and mentions the services in that same piece of marketing material, then you could submit that as your specimen of use. Again, what you're doing is just proving to the trademark office that the mark is actually being used on those goods and services that you've listed. So when you go to file, they used to accept paper filings, but they also charge more in filing fees for that. But they recently just moved to an electronic only filing system, and that's the only way I've been filing these things in the 15 years I've been doing it. It's a very user friendly form. This is the link to that form. I'll show you what it looks like in a second. One of the first things they ask you for when you start the application process is whether you're filing TEAS. We just say TEAS for TEAS, TEAS plus or TEAS standard. And TEAS plus is for situations where all of your descriptions of goods and services were pulled from that pre-approved database that I showed you. If there is even one description of goods in your application that's not from that database, if you had to come up with even one custom description, that pulls you out of the TEAS plus system and puts you into the TEAS standard system. The only difference there, really, it's the same application and everything. It just changes the filing fees. So if you're able to take advantage of TEAS plus, currently it's $250 per class that you pay in filing fees. If it's TEAS standard, then it's $350 per class. So you're paying a little more. And then there's those potential issues of the examiner possibly objecting to your descriptions. But again, if there's just nothing that accurately describes your goods or services in that database, you're going to really have no option but to come up with your own custom description. And I would say probably, I don't know, 40% of the time, 30 or 40% of the time when I'm preparing these things, I have to come up with custom descriptions. So sometimes it's just inevitable, but that's the difference there is just whether you're using pre-approved descriptions or not. As for the rest of the application, though, it's just basic info. So you're providing the applicant's name and contact info. If you have a company formed already, then you should probably just list that company as the applicant. You specify the mark, you specify the descriptions of goods and services, you provide the use information if you're filing based on actual use, and then you pay the filing fees. And so I will show you then what that looks like. So this is basically, this is a PDF version of the application. So you click these continue buttons and it takes you like from one page to the next. So again, this URL is provided in the slide deck. And so again, the first thing you do is you specify T's plus or T's standard. Oops. And so you click the radio button, and then is an attorney filing this application. You probably do know for that if you're doing this on your own. Click continue. And then the next page, it'll take you to just a bunch of text boxes where you're filling in the applicant information. So if it's you personally, you put in your name here. You would be an individual. This would open up some more text boxes. Like if you're an individual, it'll ask you your country of citizenship. If you're a company, it'll ask you like what state your company is registered in. So if it is like an LLC or a corporation, you would click the appropriate radio button here. You provide your mailing address, so address, city, state, zip. You now have to provide an email address. You'd want to probably provide your phone number as well if you're doing this by yourself, because oftentimes if an examiner has an easy issue, they'll just call you rather than issuing like a formal office action. Sometimes they'll just try to call or email you to resolve the issues. And so you definitely want to put your phone number and email address in here. Website address is optional, fax number is optional. But again, it's just basic info here. And then it goes to the next screen. This is a screen where you would actually specify the mark. So again, you're probably going to be going for the word mark. So you literally just type the mark in. Typically, when you're dealing with trademarks, you put the trademark in all caps. It technically doesn't matter. It's just kind of what usually trademark attorneys will do just to specify a trademark is it's just shown in all caps. But again, being a word mark, it's not limited to any particular font, color, stylization, capitalization, etc. So even if you list it in all caps here, you could spell it however you want as far as capitalization and everything. But it's important though. One thing that does matter is if you have, let's say again, going back to my mark, Red Wolf, if I wanted to use that as one term with no space, then I should spell it like that with no space. If I do want a space, then I need to show the space because that is considered a difference. So like if I were to show it as 2 words instead of 1, and then I submit a specimen photo that shows it as Red Wolf as 1 word on the products themselves, the examiner is going to take issue with that, and then I either have to change the mark or change the mark on the either change the mark on the application or the mark on the product itself so that they match. So you want to make sure the spelling's accurate, the spacing's accurate and everything, but typically just showing it in all caps is what we typically do. And word marks are what they call standard characters. So that's what they mean there. Special form is like if you had a stylized mark. And in that case, if you do the stylized mark, I would say if you're going to do this yourself, do it as like doing it as a word mark is probably fine. If you're trying to do a stylized mark yourself, that could be not the best idea. I mean, it's just there's more to do with the stylized mark, and again, if you don't do it right, it might be difficult to cure. So if you're trying to register a stylized mark, you might consider bringing in an attorney to help you with it. But you would click the special form button. You would actually upload an image of the stylized mark. And then there's a few extra things, like usually if you do a stylized mark, we would do it in black and white or grayscale so that color is not an extra limitation. So I would typically check this box to say that color is not one of the limitations of the claim. And then you'd also have to then describe what the what the mark looks like, or what design elements are in the mark. And so this has a little more flexibility, where if you don't quite describe it accurately, usually examiners will work with you to fix that in the application rather than you having to refile it. But these are just extra things you have to do for a stylized mark. And so then you click continue, and then the next screen lets you add the goods and services. If you're under T's plus, you just click this button and it'll take you to this search window. You type in whatever those pre-approved descriptions are, and it'll bring up a list of results. You just find the one that matches what you searched for. You click the box, and then click it. There's like an insert button. You click that, and it brings you back to this page, and it'll basically show the goods that you've selected down here listed. If you're doing the T standard, where you have a custom description, there would be this extra button to push to click, where you could add your custom description. And then there's like a little text box here that opens up, and you just type in your description, and then you select the appropriate class here. And then at the bottom of this window, there's section 1A. This is, and they've got the little helpful hints here. So this is if you're filing based on actual use. This, you go section 1A. If it's intended use, it's section 1B. Don't worry about these two. So you check the appropriate button here. If it's actual use, this little window opens up, and then you attach your specimen, again, that product photo or that marketing material. You have to describe what it is. So if it's a product photo, you just basically say product photo. If you're doing a website screenshot of marketing material, you have to provide the URL and the date that you took the screenshot. Here's the where you put the dates. So again, date of first use of mark anywhere, date of first use of mark in commerce. So in commerce means across state lines. So you pop in those dates there. You click the assign filing basis, and then it makes it based on actual use. If you checked intended use instead, if you're up here and you click the 1B, instead of seeing this, you'll get this little message. Basically, it just basically making sure that what you're clicking is what you intended to click. That you haven't yet used the mark, you intend to use the mark soon. So you just check this checkbox and then click assign filing basis. And then that's the last thing you have to actually populate. After that, there's just this kind of general declaration. Basically, you'd have to check all these boxes to say everything that you put in this application is accurate to the best of your knowledge. You electronically sign it, so you can see that's an example of electronic signature. Basically, just your name between two slash marks, or you can do whatever you want between two slash marks as your signature. You put in your info here. If it's an individual, you just list your position as owner. If it's a company, you would say you're president or managing member, whatever your title is within the company that's listed as the applicant. Give your phone number, and then it'll take you to this final page where you can you have one last chance to review everything if you want. But otherwise, you click this checkbox to confirm everything, and then you click pay, submit, and then it'll take you to like an online payment system where you can pay by credit card. Once you do that, once you submit, then you'll get an email confirmation with an electronic, what's called a filing receipt. Then from there, it typically takes about 3 to 4 months currently for your application to be assigned to an examiner. And then you would get a response again within about, say, 4 months. If there's any issues, they'll let you know at that point, or otherwise it'll just kind of continue through the process. And if you filed based on actual use, then what happens is your application passes examination. It's then published for what's called an opposition period. So the public at large is given 30 days, this 30-day window, to formally oppose if they think that you shouldn't be entitled to getting that registration. Typically what happens is if someone has prior common law rights or prior federal rights that weren't properly considered, they'll formally oppose and state their position. And then you kind of have to argue it out if it's something worth arguing over. But I mean, 9 times out of 10, that opposition window comes and goes with nobody formally opposing. And so then after that window closes, typically if your application is based on actual use, then roughly roughly 3 to 4 weeks after that opposition window closes, the trademark office will mail your registration certificate. If there is one or more classes based on intended use, then you'll receive what's called a notice of allowance. And that basically is just saying your mark passed all the formalities, but before the trademark office will give you that registration certificate, you have to actually begin using the mark in commerce. And so that will start a 6-month window within which time you have to submit what's called the Statement of Use. And it's basically that Statement of Use is another form on the Trademark Office website. And it basically asks you for that same use info. So they want to see a specimen and they want those dates of first use. And so once you submit that, they will then, assuming everything looks good, once it passes their review, they will then issue the registration certificate to you. So you technically have 6 months from that notice of allowance mailing date, but if you end up needing more time, you can request extensions of time in 6-month increments, and you can request up to 5 of those. So you can push this out by like roughly up to 3 years. And depending on how much time you actually need. So each of those extensions does come at a fee. It's basically like $125 per class, per extension. And then the Statement of Use step also has a fee attached to it where it's $100 per class currently when you submit that Statement of Use. So because of that, I mean, the cheapest path forward is to just file based on actual use. So if you're already using the mark, or if you're close to launching your product, say within like a matter of a couple weeks or so, you might just choose to wait and then file based on actual use. I mean, the further out you are from actually launching, the more it would make sense to just file based on intended use, because the longer you wait, the higher the risk becomes that someone else might start using the same or similar mark, or even file an application on the same or similar mark before you get a chance to, and then you're kind of out of luck at that point. So typically that additional money on the intended use route, it tends to be money well spent just compared to the peace of mind you get knowing you've locked your name in as early as possible. So yeah, again, I think that's about it for me. So if anyone has any questions, I'm happy to answer them now. Otherwise, I'm always happy to answer things offline. Here's my contact info, my direct number, and my email address. I'm always happy to answer questions by phone and email. Yeah, if you end up wanting help filing a trademark application, I'm happy to do that. Or again, if you do it on your own and then end up getting hit with one or more rejections, I'm happy to take things from there as well. Yeah, that's about it.
Great. Thank you, Justin. This was very informative.
Yeah.
I do have a quick question. Do you need to actually have an entity? So is micro-entity still an option for trademarks? And if so, does one need to have an actual entity set up, or could you file micro-entity under your like a sole proprietor name?
Yeah, so the entity size is only on the patent side of things, not trademark. So the trademark fees are based solely on those descriptions of goods. So it's either T's plus or T standard, depending on the descriptions. They don't consider the type of entity. But no, that's a good question. So I mean, hypothetically, if you haven't yet formed a company, you can file under your own name personally as the owner applicant, and at any point down the road, you can transfer that ownership to somebody else through what you'd have to have what's called an assignment, where it's just basically a written agreement where you're transferring all right, title, and interest from you over to a company. Once that happens, you can then record that with the trademark office. There's like a separate form. You submit that, you provide them with the new owner information, and then they charge a fee of, I think it's like $40 right now, roughly, per application, or per mark. So you pay a little fee to the trademark office, but yeah, you can definitely, this can change ownership at any point. And so that does happen sometimes, where it's someone that wants to lock in a name, but they haven't yet formed that corporation or that LLC, but they want to get their name in queue as early as possible. They can just file it in their own name personally and transfer it later.
If I may, tagging on to that same question, could you potentially use this and trademark a word for personal branding purposes?
Yes, and it just comes down to what goods or services you're providing, though. Like you'd have to still provide something, because trademark law and trademark rights are all about consumer-facing source identifiers. And so, like, if I wasn't providing anything to anybody, I couldn't register my name. But like if I was providing consultation services, even, or graphic design services, or whatever it may be, then yeah, you can definitely pursue that. Now, I mean, it comes down to, though, whether that mark is distinctive enough. Now, usually names fall within that merely descriptive category on that spectrum of strength, so they're still potentially protectable as trademarks. It's just it's kind of at the weaker end. But then if someone else is already using the same or similar name in connection with those types of services, you would not be able to register that. Now, whether you could still use your name is kind of another issue. I mean, most likely you could, because I mean, it's your name. You'd have to be able to legally advertise who you are behind those services. But the registration would just being able to register would hinge on who might have already registered something similar.
Thank you.
Yeah.
So if anybody else has questions, please feel free to unmute yourself. I also just wanted to let you know, I put my email in the chat box. So you can email me for this presentation, or if you have questions about starting a business or about your current business right now, I can always be available by setting up a separate Zoom call. Susan, did we answer any of your questions? See, we also have Rob, Leonardo, Matthew.
This was fantastic. Thank you.
Oh, you're very welcome.
I might have questions later.
Yeah, no worries. Like I said, I'm always happy to answer them. So feel free to just call me or email me whenever.
Thank you. It was a lot of information, and I think it also helped to see you demonstrate how to do the Boolean searches. Is that correct?
Yeah. Yeah, and again, I mean, you see that there's a lot of other fields that can be searched on, but usually for clearance searching, those are the main ones that you would search on. So the basic index, the international class, and live or dead, and sometimes the goods or services are the main ones. Those other ones are used for other purposes typically. But yeah, and again, I mean, it comes with practice, and there's no perfect science to those searches, but the more you do them, the easier it becomes. But it's all, yeah, case specific, and you can definitely do multiple searches to try to drill down and see what other marks are in your space. And again, I mean, if you get to that point and you're just not sure, that's something where I or another trademark attorney could kind of step in and provide some more guidance, because it's not always cut and dry. Like even in that Wolf case, that an examiner still might at least initially refuse your application as being confusingly similar, and then it's just a matter of putting forth arguments to say why they're wrong, basically, in a nice way. But so yeah, I mean, just knowing or having that idea of kind of what your chances are and whether there might be some pushback, because that could be a reason to not go with a mark if you might end up having to spend more money to actually get that registration, whereas maybe you had another mark in your short list that's going to have a clearer path forward. That could be a reason to go with the other mark. So just to avoid that uncertainty or those additional costs. But yeah, it's all case specific. Even those results, I mean, the crowded field and everything could counsel one way or another. And but it's definitely helpful to do before spending any time or money going with a particular mark.
So if we use Nike as an example, right?
Yeah, but never use Nike in the real world. No,
I'm going to use mine.
Yeah.
If I wanted to register my logo,
Mm-hmm.
I would have to fill out the application after doing a search and everything was clear. I would have to register my company name as the general word mark.
Yeah.
And I would have to put the actual image of the logo in the stylized?
So those would be two separate filings that you would do, and so that's why those are radio buttons. Like you click one or the other. You can't do both in the same application. That's a good question though. So yeah, you would go through the process once for the word mark, and then you go through the process a second time, filling out the application a second time for the stylized mark or for the logo. And yeah, you'd click that stylized mark radio button. You would upload an image of the logo, again, preferably in black and white, or at least grayscale, so that you're not trying to claim color, because then that's just one extra argument someone could use to try to say that there's no likelihood of confusion if you have a certain color scheme that they're not using in their own mark. So always go with black and white or grayscale when possible.
Do
Yeah.
people ever just register the logo and not their name?
Sometimes, yeah, and it really, I mean, it just depends on the availability of the mark that they're trying to pursue, or the name they're trying to use, and all that. But yeah, I mean, that's all case by case as well. And sometimes we come to the conclusion that a word mark is just not available because of other marks that are already registered, and such that the only option is to register like a stylized version of that name, or sometimes just skipping that and focusing just on like a logo that doesn't incorporate any terms. So I mean, it's not typically the best way to go, just because, I mean, this is protecting your brand, and aside from that, you want to have a brand that's actually going to be locatable and discoverable by potential customers. So if you end up using a mark that comes close to your competitors, even if we conclude that, well, you're probably okay to use it, there's no infringement concerns, but is it going to still be so similar to where someone searching for you is going to end up stumbling upon your competitor's website instead, and now you've lost business because of it? So there's other reasons why you want to come up with a more unique mark. Even if there's not an infringement issue per se, you want to make sure that you have a mark that kind of stands apart for that reason.
Thank you so much.
Yeah, of course.
Just one more time, how long do you need to be in business before you can use the actual in use versus intended use? Is it like, do you have to sell like so many items, or
No, I mean, technically it just takes one sale. I mean, legally speaking, they want to see if there's only been one sale, there has to be like a present intent to make additional sales in the near future. Like you can't just only sell one and then like not do anything for a year or so. It doesn't smell right, doesn't pass the smell test to the trademark office. Even there though, the trademark office usually is not going to raise that issue. It would come down to like a third party challenging the validity of your registration. They could turn up some evidence to show that it wasn't a legitimate sale. But I mean, technically speaking though, the day that you make that first sale or shipment across state lines to a legitimate customer, you're legally using the mark in interstate commerce as of that date, and you can legally say that there's actual use as of that date. So it just takes one legitimate sale, or not, again, not necessarily even sale, one providing the goods or services across state lines to one legitimate customer, because again, money doesn't even have to exchange hands.
Perfect.
Yeah.
Wonderful. Thank you again for your time. I really enjoyed your presentation. This is wonderful and really well thought out, presentation. So again, thank you again. And so if anybody else would like to reach out to Justin, his contact info is there. I will get the presentation from Justin and go ahead and send it out to those people who are interested. And with that, thank you for joining. Susan, I hope to see you at the next one. We do it every 2 weeks. And Leonardo and Matthew, if you're still there, we'd love to see you as well. So with that, thank you.
All right, thank you again.
Okay, bye-bye.
Bye-bye.